Page 388, section 147. The scope of this division is not merely technical spendthrift trusts and other trusts aimed at protection of beneficiaries against their alienees and creditors, but it includes all trusts aimed at protection of beneficiaries in present or future support and maintenance, including education, even though their protection may be merely against the direct control of the res. Okay, direct control of this res, it's prohibiting us from being in direct control of this. You can basically say that that's exactly what that just said. Or income of the trust by the beneficiary, and not against alienation by him or against his debts. As a matter of fact, two chief situations exist where a support or similar trust is protected merely against direct control by the beneficiary of his interest in the trust estate. Okay, down further you will see, about the third line up, it's basically to protect himself against his own improvidence or incapacity of management, a trust of which character cannot, according to the universal rule, protect the settlor against his own acts of alienations or debts. Now this 14th Amendment so-called trust under the Federal Reserve Act is supposedly protecting our improvidences in this. You know, like if we had this, we couldn't handle it correctly. They may be right. There's a lot of ignorant people in this world. God forbid. I mean, our country is already in the hands of ignorance. I should know. I have been there. I have been ignorant. We all have. Let's try to find more understanding and bring ourselves out of darkness. Okay, definitions and distinctions. In a broad sense, a spendthrift support or other similar protective trust is one created to provide a fund for the maintenance of the beneficiary, voila, the Federal Reserve Act, and at the same time to secure it against his improvidence or incapacity. So therefore you see that the Federal Reserve Act was totally lawful for certain persons. Okay? In other words, it bars such interest from seizure in satisfaction of debts. The name Spendthrift Trust is poorly descriptive, since no spendthriftiness or profligacy. Thank you, profligacy. You say it. I'm a little tongue-tied. Sometimes I flip words around. A little, you know, of a beneficiary is requisite or open to inquiry and determination of the existence of such trust. While spendthrift trusts are usually regarded as inclusive of all trusts, which bar creditors from reaching a beneficiary's interest, that's interesting. I think the banks really get to us. They are in strict legal nomenclature to be distinguished from other trusts seeking to protect a trust estate against the grantees. Now, let's see. Down in the next section, there will come up the word inherent. Okay, if they're assuming there is no inherent objection to spendthrift discretionary support and other protective trusts, I don't recall anybody having any inherent objection to the Federal Reserve Act. Nobody complained about it at the time. Certain prerequisites must appear before a valid trust of this kind can be said to be created. While it is not essential that the beneficiary be in fact a spendthrift, or that the settlor state his reasons and motives, it is essential to the existence of a trust of this character that there are some restraints, okay, on the immunity or of the interest or benefit of the cestui. Now we're placing controls on the beneficiary here. In section 159 on page 398, you will see that a beneficiary of a spendthrift trust may, prior to accepting the trust, effectively disclaim or renounce the trust. They didn't even tell us that was available, did they? Now, on page 413, or should I go backwards one more?
On which page?
Let's go to 413, section just above section 177. The last paragraph says, a beneficiary of a spendthrift trust has been required to repay an overpayment to him out of the trust. Okay, we start seeing the 1040 here. You're a spendthrift beneficiary of a spendthrift trust, and every year you've gotten too much money from the trust res, so you have to return some of it on that 1040. Page 415, section 179. The beneficiaries of a spendthrift or other support trust are entitled to the benefits conferred in accordance with the terms of the trust, expressed or implied. Of course. Generally speaking, the operation and effect of such trust in respect to benefits are governed by rules and principles applying to provisions for support, whether in wills, like the 14th Amendment Codicil, deeds, contracts, declarations of trust, or other instruments. Support trusts quite commonly are based on support contracts. There's your Social Security Act, a support contract. And being thus purchased for a consideration. Here's your Uniform Commercial Code. Subject to, what did you buy? Where's the contract? Or is all of this falling in? Okay? I hope so. Section 180, where it's marked down, where it starts, such a trust casts upon the trustee the duty to exercise sound judicious judgment, to determine what is necessary for the support of a beneficiary, and to turn over to him trust income or property or funds in such amount in accordance with the terms of the trust. Page 417, section 182. The trustee under a spendthrift or other support trust is often vested with discretion to determine the occasion or amount of support payments or other benefits or other occurrence of or compliance with conditions entitling the beneficiary to a payment or to the corpus of the estate. Now this is saying that they have the right to determine what we can have. Now, if you have never been in an audit with the Internal Revenue Service, you will not relate to this. If you have been in an audit, you will actually get in your gut that they are making the determination as to what you can have. Well, we disallow this. Well, we disallow that. And you're sitting there going, I did this in full faith. I did this in honesty. And they're throwing it out the window. And that person is determining what I can have.
Or you only treat this as a person,
On the next page, you will find a request for an OMB review. This is SF 83, Standard Form 83. This is regarding the Social Security number. This comes from the Office of Management and Budget. In number 4 there, you will see it does refer to the Social Security. It says application for a Social Security number card, original replacement or correction on Form SS5. Please forgive that these things have dark backgrounds because they were marked in a pencil or marking device that that was copyable. We weren't quite sure. When you look at this carefully, you'll notice in number 9, it says CFR section affected. There are none. And if you go to the next page, it'll give the description, Social Security benefits, application number, original replacement, etc. And a pertinent part of the form is number 24. Respondent's obligation to comply. You will notice that number 1, voluntary, is not marked, neither is number 3, mandatory, but number 2 says required to obtain or retain a benefit. That is what a Social Security number and card is for. That comes directly from the OMB, which is the office below the President of the United States. Now, the Federal Reserve Act created the trust and the fund of the trust. The Social Security Act created your ability to receive benefits, and the number here shows, or this OMB request shows, that it is only to obtain or retain a benefit from this spendthrift trust fund. Page 419, section 184. In the absence of anything in the trust declaration indicating the amount of support benefit, which it wasn't in the Federal Reserve Act, to which the beneficiary is entitled under a spendthrift or other support trust, the amount thereof is to be determined by the trustee in the light of the station of life, your status, and mode of living of the trustor and the beneficiary, the relationship between the two of them, or between them, and the needs of the beneficiary. Here's your 1040 being defined. It's starting to be defined, I should say. Okay, the Internal Revenue Service now comes in. The trustees make a determination. What is your status? Please send us your Social Security number so that we might know who you are. What is your status in life? What is your status in this country? What is your status in relationship to the preamble? What is your estate? 422, page, section 187. While compliance with or the occurrence of conditions precedent and conditions subsequent, it is a requisite to the right to receive. Remember that from the charities. Or retain the benefits of a spendthrift, support, or similar trust containing such conditions. Compliance with or occurrence of conditions precedents and conditions subsequent. I could go into that, but conditions precedent and subsequent is another book, another page. Okay, now 423, place of support. How many of you have heard that the income tax applies to you no matter where you reside?
Yes.
Okay. Section 188. A beneficiary of a spendthrift or other support trust generally is entitled to support, of course, or other benefit under the trust irrespective of where he resides. This ties the two in. You're subject no matter where you reside. You can receive the benefits anywhere you reside. This is... everything starts tying in together now. Melding, becoming one, becoming clear. Page 427, application of statute of frauds and wills. A trust by operation of law, whether it is resulting or constructive, is not within the statute of frauds, and is not required by the statute to be created or proved in writing. Neither do the provisions of the statute of wills apply to the creation of such trust. Such trust may be established by parole evidence. Okay? Further down in there, a trust of this kind arises from the fact of consideration, or the fact of fraud or wrongfulness giving rise to unjust enrichment, and not from a written agreement, instrument, or will. And rest on estoppel. The purpose of statutes of fraud is to prevent, not to permit, the consummation of fraud or unjust enrichment. Now, we skipped over a few things here, but we're getting into the idea of a constructive trust is created because there's fraud located somewhere there. I call the 14. I call this, when I'm talking to the bureaucrats at this point in my life now, I call it a constructive spendthrift trust by implication of law. Okay. I think it's a good terminology. I say it's a spendthrift trust. There is fraud involved somewhere here, so it's constructive, and it is basically, and again, by implication of law, because you can't find it written down anywhere. It is definitely implied. There is definitely an implication that this thing exists, even though they failed to inform us and to write it down so that we could see it and find it. You could even call it a spendthrift trust by implication of law, or just spendthrift trust. Definitely have spendthrift trust there. Resulting trust, 429. The doctrine of resulting trust is a familiar one in equity jurisprudence. Broadly speaking, a resulting trust arises from the nature or circumstances of consideration involved in a transaction whereby one person thereby becomes invested with a legal title but is obligated in equity to hold his legal title for the benefit of another. Here is the constructive trust, 446, section 221. A constructive trust, otherwise known as a trust ex maleficio, a trust delecto, ex delecto, a trust de son tort, an involuntary trust. Involuntary, that's why I call it constructive spendthrift trust, okay, or it's involuntary. It's also one created under tort, their tort, or an implied trust, is a trust by operation of law which arises contrary to the intention and invitem against one who, by fraud, actual or constructive, by duress or abuse, those are familiar words, of confidence, absolutely, by commission of wrong, or by any form of unconscionable conduct, artifice, concealment, or questionable means, or who in any way against equity and good conscience either has obtained or holds the legal right to property which he ought not in equity and good conscience hold and enjoy. Somebody's got my property and I want it. Perpetuities. Perpetuities, okay? Now, if you look at this and you go, okay, it's perpetual, there is a rule against perpetuities, okay, but it does not apply to charitable trusts. It applies to private trusts. That's what makes this a charitable trust. That's what makes the 14th Amendment a charitable trust. This makes them kosher in the eyes of the perpetuity rule. Okay, now they can last forever and ever and ever.
Oh, man.
That's why I've been bringing all this stuff in charities in here. Because you can't just say, well, it's a trust, and say, well, what about the rule against perpetuities? Oh, you wouldn't know what to say. Well,
this is all statutory law.
This falls under, no, this is common law. Well, no, what I'm talking about is common law, okay, and that they've diversified common law to statutory form.
Perpetuities, though, is basically
Oh, perpetuities go back a long time, yes, long, long time, to the statute of uses, because that's what they wanted to break in England on the corporate structure of under Mortmain. They were trying to break the perpetual hold of Mortmain through the Catholic Church. Corporations are not subject to perpetuities, okay? And the Catholic Church had England in its grasp, its death grip. So way back when is when they came up on the perpetuities in regards to trusts, so that a private trust could not be perpetual. Okay, a charitable trust could be, but there are a lot of restrictions on charity. That's where the rule of Shelley's case is, goes way back. Okay, I told you once that restraint on alienation was found under perpetuity, so I've thrown some of it in there. Okay. The general rule is that one of the incidents of ownership of property is the right to convey it. Okay, and the law will not permit the rights of ownership to be fettered by the imposition of restraints by grantors or testators who seek to convey or dispose of their property and at the same time maintain control over its alienation or use. The United States government has restrained my alienation on this property, and it is a restraint on alienation under this right here. They're trying to control my property, my estate. This cannot be allowed. Thus, whether imposed by deed or will, deed or 14th Amendment will, restraint on alienation is ordinarily a void, except under the 14th Amendment it's a spendthrift trust, and remember it doesn't apply to spendthrift trust, so therefore restraint on alienation is perfectly valid under the 14th Amendment, and that makes the Social Security number okay. The Federal Reserve Act is okay. It's all legal and lawful. On page 110, statutory and constitutional provisions. Ever since the passage of these statutes, and we're talking about quiem turis and other English statutes, okay, the right of alienation has been treated as an incident of an estate in fee simple, and one which cannot be avoided except by an agreement which is not unlawful, impossible, or repugnant to the grant, or inconsistent with enjoyment of the estate granted. Okay, that's how they created the 14th Amendment. It truly is not repugnant to this. Okay? Like I said, you can't have a large estate and make it into smaller estates. So, again, we say that the 14th Amendment doesn't, you know, the restraint on alienation does not apply to there, but it does apply to this. So we got to go for that allodial title, that fee simple absolute. On page 119, restraints as to persons. According to the prevailing rule, where a deed or device in fee simple contains a provision or condition limiting the class of persons to whom the property may be aliened, or excluding a certain person or class of persons from owning such property, such an attempt limitation on the right of the grantee or devisee to alien the land is void. We keep coming up with this voidable thing under the restraint on alienation. Did I mention that I sent the Social Security Department a affidavit in support of restraint on alienation? I defined their restraint on alienation as a number that they had given me under mistake of law through non-disclosure. It's a nice two-page little article. It's an affidavit, basically. Unlike the revocation of powers of attorneys that some people are putting in, this hits straight toward an estate because I brought that up. The fee simple absolute. I put them on notice again and again. And it's about the fourth time I put them on notice of something, but this time it's on their restraint of alienation.
Any response?
It was just a couple weeks ago that I did this.
No response yet. Okay.
No, I gave them 10 days, but they didn't respond in 10 days. So.
That's all we give you.
Hey, 5 minutes is too long. Yes, that's right. That's how long they give you. And we're going to continue on here further. Let's see, where are we here now? On page... You'll find something that says up the top on the left-hand corner, section 275, general provisions. This comes from the California Probate Code. Section 275, beneficiary filing disclaimer. A beneficiary may disclaim any interest in whole or in part by filing a disclaimer as provided in this part. What are we disclaiming?
Federal law.
This is under probate code. We are disclaiming being a beneficiary under the constructive spendthrift trust by implication of law. We are revoking elections. Disclaiming. We are not going to take under the will. Okay? It's a disclaimer. This is the probate code. This gives you the right to disclaim taking under the will or, revoking those elections or saying, hey, something about the elections that was forced on you. On the next page is section 280. Filing of disclaimer. A disclaimer may be filed with any of the following. Number 1, the Superior Court. A disclaimer shall be filed with any of the following. Number 1, the Superior Court in the county, etc. Number 2, the trustee, personal representative, or either fiduciary or person responsible for distributing the interest to the beneficiary. Now this is the government, the trustee, the representative, the corporate capacity. Okay, you can file your disclaimer of testamentary interests, as you may, with the government, state, federal, etc. Number 3, any other person having custody or possession of or legal title to the interest. Could that be the banks? Number 4, the creator of the interest. I think they're dead. 4B, the disclaimer in this part may be filed with the county, recorded in the like manner and with a like effect as a grant of real property, and all statutory provisions relating to the recordation or non-recordation of conveyances of real property and to the effect thereof applying to the disclaimer with like effect. Now, I tried to file my disclaimer with the county recorder pursuant to this section, and they have refused me not once, not twice, but 3 times. Now, I figure if they refuse to file it, it must be valid.
Not only valid, but probably deadly.
It's probably deadly. But we shall pursue and continue. Okay, probate code. Probate court is an Article 3 court. Believe it or don't. And the probate codes have wonderful remedies regarding the breaches of trusts and the accountability of the trustees and making account to you. Utilizing it, I don't know. I haven't applied it in that direction as yet. But it looks like a possibility and could open up several doors. I would love to open some doors in probate court. This is a trust, that's where it belongs. If the 14th Amendment is a trust, that's where it belongs. And it doesn't matter if it's a court of equity or not, because once a trust is brought in, the court has to look at the trust first and other laws later. The trust comes first. Now, page 188, section 278. Here we discuss the disclaimer and what you're disclaiming. You're disclaiming your election to take under the will, the 14th Amendment codicil. You want to disclaim it. You want to tell them that they took you. They committed non-disclosures. They didn't tell you of your rights as an heir to this estate. They told you you were someone else and that it was an inferior estate. This is the guidelines on how to make one. Page 203 in section 295, effective federal law, transfers of or disclaimers. Notwithstanding any other provision of this part, if as a result a disclaimer or transfer the disclaimed or transferred interest is treated pursuant to the provisions of Title 26 of the United States Code as now or hereafter amended or any successor statute thereto, and the regulation promulgated thereunder as never having been transferred to the beneficiary, then the disclaimer or transfer is effective as a disclaimer under this part. Here we have Title 26 in the Probate Code. My, my, my.
Oh, wonders never cease.
Now, as an estate, and as A conveying Blackacre to B and his heirs, in law, under common law, under English law, the heirs had to be lawful heirs. And when there were heirs, there had to have been a marriage. A marriage between the testator or whoever was doing a wife, because if there weren't, the posterity would be bastards, unable to inherit. In metaphysical thinking, there is a wife who created the posterity of this country, a mother. Your mother, my mother, my mother country. The founding fathers were married to America, and America gave birth to the heirs of liberty. In this metaphysical line of thinking, in order to separate and segregate the estate, we can utilize dower, assigned dower. It literally separates the estate. We give the widow 1/3 of the estate. We can give her this. The rest all comes with it. Now this is metaphysical thinking. How to do it? We've been trying to get in an assignment of dower also to separate the estate. And it sounds interesting, unusual, but it was a valid thing. And they were married to America. And the heirs are not bastards. We are lawful heirs. So we must have a mother, and she deserves to be assigned her dower. And it does separate the estate and get it out of other people's hands. It could be something fun to play with. In dower, you can quarantine the estate. Her estate. Just put it on sheer quarantine. Okay? These are some very beautiful things to look at, because she is your mother country. She is my mother country. She is your mother country, no matter what color, sex, religion, race, or anything that you are. She's my mother, my spiritual mother. Read the dower sections that I put in here. Try to relate back to what I said, or am saying here, about, here on page 222, on the second paragraph, the assignment of dower is essentially a different thing from dower itself. Dower is an estate, while the assignment of dower relates to the remedy for segregating the estate. Now, it's very difficult to segregate our estate from this corporate function that is going on, this mortmain situation we have. You know, God forbid, we don't want a war, we don't want bloodshed, but dower could be a possible legal way of segregating the estate. I don't foresee much hope in it, but it's a beautiful line of thought, because now we're going to get into the law of real property, freehold estates. Freehold estates, characteristics. Okay, now the 14th Amendment over here, Section 12, and that's page 58. A tenant for life of a possessory estate has a right to the undisturbed possession of the land and to the income and profits. Now we're getting into life estates. 14th Amendment is a life estate. Okay, but on the next page, it's on page 59, it says his use and enjoyment of the premises is limited by the law of waste. That is, he is under duty to refrain from any act which will diminish the value of the reversion or the remainder, if such an act is also under all of the circumstances and unreasonable use of the premises. This particular area defines the 14th Amendment estate, okay, not the trust. The trust falls under the estate. Everything goes in a nice lineal fashion. Okay, we start with the estate up here, and everything falls beneath it. There's things that fall beneath this estate, and under the 14th Amendment estate, other things fall. So these estates have been established hundreds, who knows, thousands of years back. It's like a scientific formula. They have it down pat. They know exactly, whoever they are, know exactly what something is, how it behaves, how it acts, and you don't. I swear they must have diminished the value again. These estates normally involve a duty on the part of the estate holder to make a periodic payment for the use of the land. How about the yearly 1040? They compromise the core of the landlord-tenant relationship. Ever feel like you were just a tenant on your own property? I swear they are diminishing the estates. We're going back into feudal times, into slavery. Let's go to volume 49. Landlord and tenant. There's more. This goes into whether you, now this is where employment comes in as a tenant, and I want you to read this at your leisure. See if I can, okay, while a deduction from wages of a specific sum for the use of the premises or the absence of such an arrangement would be a material circumstance, it would not be in all cases conclusive either way. Here we're talking about a deduction from wages for use of premises. Now, we're not going to go into that right now, but this is, you know, now we have a W-4 form coming in. What premises are we using? So obviously the estates are being diminished. And on page 325, you will find the W-4 further defined under assignment. This is from Amjur 2D, and assignment for the benefit of creditors. A general assignment for the benefit of creditors is ordinarily a conveyance by a debtor without consideration from the grantee of substantially all his property to a party in trust to collect the amount owing to him. Down further it says something about return the surplus, if any, to the debtor. The common law, next paragraph, also embraced, in addition to the general assignments, a non-liquidating device known as a partial assignment, by which a debtor could transfer a part of his property in payment of creditors. Now, does this sound like a W-4? And under the principle that a debtor may, while he retains dominion over his property, dispose of it as he chooses, an assignment of part of his property to part of his creditors was valid unless it could be attacked as a fraudulent conveyance. Here we have, remember, an exempt W-4? Was valid unless it could be attacked for fraudulent conveyance. Page 232, I try to show that the assignment, the W-4, is an assignment as security. Wage assignments, of course, you know, wage assignments are something totally different in the minds of human beings, but I see the W-4 as an assignment for the benefit of creditors. Okay.
Exactly.
And you do, it's partial. Origin and development of death taxes. Now, in order, since everything has to work together, Okay, someone has to die in order for a gift tax or an inheritance tax to apply. In our case, the heir dies. The 14th Amendment citizen is responsible for the estate or gift tax of the trust. And I want you to go through that when you can. Inheritance taxes. These are very important things. The legislature has the power to classify property for estate tax purposes. Now, when you look at our state and the 14th Amendment state, the legislature has the power to classify the estates for tax purposes. Since the 14th Amendment is an estate, they have the power to classify that tax, and it would have to be either an estate tax or something else. Now, when I started researching this, on the label, I wanted to find out if the 1040 was a will, a codicil, or what. And what I ended up with was that the 1040 is a gift tax. Indeed. That it was a deed, not a will or a codicil, because it took the description more of a deed than it did to a will. It is an absolute gift to a charitable use, a corporation in Maine for a charitable use. Now, I thought perhaps it could be an estate tax, but gift tax supports it better in my eyes. If you find that it's different, let me know. Let me know.
Also, the 6209 manual lists the W-4 as a gift form.
That's right. The 6405, what manual? IRM?
It's a 6209, I think.
Okay, the Internal Revenue Manual 6209 lists the W-4 as a gift tax.
Classified gift.
On page 860, Bills and Notes, section 54. A note, an evidence of debt. Okay, we are discussing. As a chosen action, a promissory note of a third person or other evidence of debt together with any security may be the subject of a gift inter vivas. Right here it says that you can give a debt as a gift. Well, I want you to know that those Federal Reserve notes are evidences of debt. And you are giving your evidences of debt as gifts. Or you're transferring them or conveying them to other people. Okay, so there you laughed, huh? Those Federal Reserve notes are evidences of debts.
Causa mortis.
Causa mortis. Please read causa mortis and gifts, because causa mortis is very important. The idea of someone has to die, okay, for a tax on a gift. Okay, and when you think that someone has to die, remember the heir here has died, the 14th Amendment citizen is paying the tax because the estate or some sort of estate has transferred. It's all metaphysical, but has transferred to a 14th Amendment citizen. The 14th Amendment citizen has to pay a gift tax because the heir is dead. The 14th Amendment citizen genocided them, along with the government. It's conspiracy. None dare call it conspiracy. Now, I want to wrap this up very quickly, and we're going to go to Title 26. Well, you'll recognize it by the top says 6100. This is Title 26. But the section is 2501, imposition of tax. This is the gift tax section. In general, a tax computed as provided in section 2502 is hereby imposed for each calendar year on the transfer of property by gift during such calendar year by an individual resident or non-resident. transfers of intangible property. Except as provided in paragraph 3, paragraph 1 shall not apply to the transfer of intangible property by a non-resident, not a United States citizen, or not a citizen of the United States. Now, do you notice that it does not say non-resident alien?
Yeah.
It says non-resident, not a citizen of the United States. Okay, and intangible property doesn't apply. One a bit. Exception, paragraph 2 shall not apply in the case of a donor, well, you are a donor, who at any time after March 8th, 1965, and within a 10-year period ending in with the date of transfer, lost United States citizenship. Now, this is about expatriation. Okay, so this one doesn't count. We just, let's involve ourselves with number 1 and 2. And go to the next page, and up the top, little b, 2501b. Certain residents of possessions considered citizens of the United States. And if you will see number C, or letter C, certain residents of possessions considered non-residents, not citizens of the United States. I want you to know there is absolutely very little difference between the two of those definitions. You'll be almost reading double when you look at them. You go, what? Wait a minute, the other one said exactly the same thing. In there, it gives the requisite for either being a citizen or not a citizen. Okay, but let's read C. A donor who is a citizen of the United States and a resident of a possession thereof shall, for purposes of the tax imposed by this chapter, be considered a non-resident, not a citizen of the United States. Didn't he just say it was a citizen of the United States? Within the meaning of that term, wherever used in this title. I only find that particular wording in this area. You could literally confuse it with non-resident alien, but these words are nowhere else to be found in Title 26. But only if such donor acquired his United States citizenship solely by reason of, number 1, his being a citizen of such possession of the United States, or 2, his birth or residence within such possession of the United States. Well, this kind of makes it, this is very convoluted. They bring up the word possession of the United States and your birth in that possession. And from what I know of the Buck Act, this is all a possession of the United States, so I'm a non-resident, not a United States citizen, according to this definition, pursuant to the Buck Act. And the wordings of both of these are so convoluted as to make you wonder what in the heck is going on.
Yeah, where did the bear go in the buckwheat?
So if you're using non-resident alien, then you're declaring yourself to be a Frenchman.
You could be a Frenchman, because I do not find this particular wording anywhere else, and it does say anywhere else where in this title, not sections, but in this title, I find it nowhere else except under gifts and estates. So, if under a state law I'm a non-resident, not a United States citizen, does that make me a non-resident alien under some other section? I don't think so. I don't think I'm a non-resident alien. I may be a non-resident, not a United States citizen, but I don't think I'm a non-resident alien. I'm an heir. I'm still going for the heir. Now, turn the page again, in section 2511, the little b portion, intangible property. Remember, the non-resident, not a United States citizen tax did not apply to intangible property. For the purpose of this chapter, in the case of a non-resident, not a citizen of the United States who is exempted from the application of section 2501A2, shares of stock issued by a domestic corporation and debts of obligation.
Frog notes.
A United States person, or B, the United States, a state or other political subdivision thereof, or the District of Columbia, which are owned and held by such non-resident, shall be deemed to be property situated within the United States. Your Federal Reserve notes are property situated within the United States. Pursuant to this definition, that's why nobody has been able to say, hey, I am not employed or getting income from within the United States. You're not. The Federal Reserve note is. This just makes it thus.
You have no choice.
So Howard Freeman's argument there figures directly to those notes.
Yeah. And where we get this from is on the next page, Title 31. Let's see if I have that marked. No, let's go to the next page over there. There's the United States can accept gifts on Section 3113. Isn't that generous of them? To provide the people of the United States with an opportunity to make gifts to the United States government to be used to reduce the public debt.
Where are you? Where are you?
Section 3113, page 249. Okay, it's Title 31. To provide the people of the United States with an opportunity to make gifts to the United States government to be used to reduce the public debt. Isn't that what your 1040 is used for?
Sure.
Supposedly. Will that public debt ever be reduced? Never. This is now you can turn the page to Section 3121 of Title 31. Little b1 says, under conditions prescribed by the Secretary, an obligation issued under this chapter and redeemable on demand of the owner or holder may be used to pay the United States government for taxes imposed by it. The obligation imposes the tax. Imposed by it. The obligation imposed the tax. And turn the page one more time to page 267. This comes from Title 31, and we're going to go to Note 58, Treasury Notes. United States notes issued under acts, etc., 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 is still valid. Intended to circulate as money, and actually having constituted with the national banknotes the ordinary circulating medium of the country, were moreover obligations of the national government. The money is the obligation. The Federal Reserve note is the obligation, the debt obligation. It is the note. It imposes the tax under the gift tax as far as I can see, or estate tax. If I am wrong, please prove it to me.
It's exempt from state tax.
And on the next page, 257, you shall find exemption from taxation. And this is the last page, and we can then talk about the whole situation. The tax status of interest on obligations and dividends, earnings, or other income from evidences of ownership issued by the government or an agency, and the tax treatment of gain and loss from the disposition of those obligations and evidences of ownership is decided under the Internal Revenue Code of 1954. Now, do you agree with me that the possibility that this is a gift tax or an inheritance tax exists?
Yes.
Do you agree with me that there is an estate of two types, one for a lesser estate, for incompetent people, infants?
Yes.
Are you heirs of freedom also?
Absolutely. Absolutely.
Well, I want you to tell everybody you meet, or introduce yourself, or proclaim your heirness, your heiress-astrariousness. Because when I found this, I thought it was the most beautiful thing I've ever found in my entire life, and it just all fell right down into place. And there is much more to see, but I tried to give you just the bare essentials and try to keep it as clean and clear, so not truly confuse you. And if you go out and research it, please be aware that they have commingled the two estates. This is not correct, nor is it right, nor is it legal, nor is it valid. When you have a trust, if you own corn, and the trustees make whiskey, you still own the whiskey and the dregs of the corn. And you have to identify the property. It's called tracing the trust, or what is it called? You're actually tracing the property, identifying the trust property as it goes down. If you can identify the property, you own it. For example, the right to travel is part of this estate. Oops. And I ran across something very interesting on pedestrians. A pedestrian has a right to travel on any means of conveyance he chooses. He can use a highway anytime, day or night. Is a pedestrian perhaps whiskey from our corn? Because that's where the right to travel has gone, this constitutional right. It started looking very interesting to me in the DMV code when it didn't define a means of conveyance. And as a matter of fact, I can't really find the definition of a pedestrian too clearly defined either, except that he does have the right to travel and that he can use a highway anytime, day or night. And there are certain rules that apply to him, the rules of the road.
Yeah.
And it starts beginning, there are some court cases that we're trying to find and bring up regarding how they define pedestrian, and could it possibly be that this is trust property convoluted? Because when they convolute and commingle the trust property, it's illegal. It's an illegal action on the trustee's part. What you owned as corn is now whiskey, and you can't identify your corn in liquid form.
No, you can get over it.
But the whiskey still belongs to you. All you have to do is identify it and trace it. Trace how they brought it down. Ladies and gentlemen, do you have any questions?
Point. If you can't get it, the dower or the assignment of dower registered with the county clerk or whatever, might I suggest maybe putting it in a paper where it becomes public knowledge, and thereby if everybody knows about it, this estate is separate.
Well, I could do that. However, I don't have the funds to do that at this point. It's rather expensive. There are other means of doing it. We could publish it on a courthouse wall, and then by affidavit prove that it had been published in the courthouse wall.
Yeah, that would be the way out.
Now, there are ways to do it. There are many ways to attack. I also wanted to touch upon the fact of their oaths and their bonds. Okay, at some point in here, I mentioned that they took oaths, they had bonds, they had duties. Okay, now in employees and officers, employees, okay, of AmJur, the oath, the bond. There is a contract between the sureties, their insurance, whoever insures them, okay? They have sureties. The officer is a principal, and you are the obligee, okay? There is a contract between the three of them. They owe you a duty to uphold the law by way of their bond. They have put up a bond saying that they are going to uphold the Constitution of the United States. This is their oath. When they breach this oath, the oath to support this, they default on their bond. When they default on their bond, they break a contract, and now we have a way to possibly go toward the commercial lien process because they have left it open themselves. And when it comes to their oath, this is the only place that God resides in their universe. This is an oath to God that they will get the punishment of God and as free agents of and representatives of God on this world. I will go after them. I am his free agent and his representative, and he shall find us a way, because this belongs to him and he gave it to me. May God bless you.
Amen.